Good morning and welcome to everyone who's joined, to our audience, to our employers out there. I'm Carl Ranger, Head of Training at CEO. Today, I'm joined by Jean-Andre Kruger, our National Operations Manager. Jean-Andre, welcome.
Morning, Carl. Thank you very much. Thanks for having me.
Thank you for being here. We've got a very interesting information session this morning. It shouldn't take too long. We just want to inform everyone about what's going on with the recent judgment. There was a recent judgment in the High Court regarding parental leave and affects employers, and it'll affect the upcoming policy changes. So we want to just discuss that. To kick off, I'm just going to go through what the current stance is for the Basic Conditions of Employment Act for everyone out there who doesn't know. The current stance is that there's 4 months maternity leave offered to mothers of birth children. The supporting partners used to take family responsibility leave. However, that was amended in January of 2020 to 10 days parental leave for the supporting partner. So together with that, there's also obviously 10 weeks of adoption and surrogacy arrangements as well. So what has happened currently, the judgment in the High Court, is the stance on that is changing in the upcoming 2 years. Jean-Andre has recently written an article for our CEO blog, which will be posted on all our social platforms, as well as on our CEO website for all our audience to read. So you guys can go through that. It'll also be posted in the comments and on the banner at the bottom of the screen. Jean-Andre, if you could maybe just take us through the judgment and the background and how it's actually impacting employers at the moment.
Yeah, thanks, Carl. Quite an interesting judgment. I know the media has already run away with it, as they usually do. You know, a huge win for fathers and stuff like that. Yeah, look, the Van Wyks took their employer to court, or actually not their employer. The employer's organization was a party to the dispute, but actually the Minister of Labour, challenging the maternity clauses within the Basic Conditions of Employment Act. Basically just reaffirming that family dynamics are changing, and gender roles are maybe mixing up a little bit, and the fact that mothers were historically always the ones who nurtured the children, and the men were usually the ones bringing in the income and supporting the family. So they basically went on. Mrs. Van Wyk owns 2 companies. She wanted to go back into business immediately after the birth. So Mr. Van Wyk approached his employer, said, listen, he would like to take the maternity benefit, to obviously become the primary child carer during that first initial period of the child's life. Obviously went to the employer. No fault on the employer's side. I think, we're all learning to adapt to the new world and these new roles. So they obviously made it clear that their policies currently didn't, cover the husband or the father taking the maternity benefit, and rather more the paternity benefit as it's been known, and we'll touch a little bit on that. And inevitably they went to the High Court to say, listen, they find that the maternity clauses are unconstitutional. And well, as we can now see, and I mean, we're not going to rehash the entire judgment here today, but you can see from the judgment, the judge has taken into account that, gender roles have changed, and we're moving forward in a different world. So they basically then said that, look, the clauses as they stand right now are unconstitutional. The judge then went further and said, listen, that he would provide the state or the legislature a 2-year period to correct these defects and unconstitutionalities within the Basic Conditions of Employment Act. Obviously, the media ran with that 2 years, policies need to change, but clearly, it's not really like that. It's not something that is going to change immediately. So just from our perspective, something to maybe tell employers, what we tell all our employer members as well is, don't panic yet. Nothing is changing yet. But the winds of change are certainly here. And, this information session today might help them to, feel a little bit more comfortable in what they need to do going forward.
Yeah. On that note, for our audience, please feel free to ask questions. You can pop a question into the comments there on the YouTube links, on the LinkedIn and on Facebook. We will address the comments as we go. So please feel free to pop a question or add a comment if you have anything that we can address it live. Jean-Andre, so a lot of people are saying this is a win for fathers in particular, with regarding the paternity leave of 10 days or the supporting partner having 10 days leave. In reality, it's more of a gender equality win. But If you look at the period and the outcome of the actual judgment, how does that now change from the current stance? Where are we regarding the actual leave?
Yeah, look, and I see already, Lauren from Starful, thank you very much for your question. When will the changes come into effect? And the short and long answer is we don't know yet. It's definitely not immediately applicable. What needs to happen from here is, and as you said, this is not a win for fathers. If you ask me particularly, and I mean I'm speaking as a father, it is a win for the gender equality and moving forward as to how family setups work. So to answer Lauren's question, the judges made certain recommendations that he would say, listen, the act needs to change with, and very small ones at this point. He's basically just substituted certain words in the entire maternity section and the additional sections now, that include the paternity leave and the adoption leave and so forth. He's then said, listen, within 2 years. But in reality, that's not really what's going to happen. The matter is now going to be referred to the Constitutional Court, because the Constitutional Court is that's where the buck ends in regards to constitutionality. So what's going to happen there is the matter is going to basically be reheard by the Constitutional Court. The Constitutional Court will then again hear submissions. It's almost very much like a case de novo. Don't ask me why always, but I mean that's how the legal system works. And after that, and after hearing all the evidence, and it might be noteworthy that the Con Court can also hear new evidence. They're not bound by the evidence that was given in the High Court. They will then make a decision, the final decision on the constitutionality, and then they could either, well, they're probably going to give a judgment to say, listen, this is the interim stance, and how long will it take before that interim stance will take effect? They will then give the state or the legislature a certain period to correct the act. And in all likelihood, they will correct the act. And we'll touch a little bit on a few things I think they'll be doing. But if they fail, then the interim judgment from the Constitutional Court will, in effect, be the status quo. So, Lauren, at this point, they will not take in effect anytime soon, minimum 2 years. But if you have a look at the Constitutional Court role, and from one of the advocates that also dealt with the matter, she also clearly stated that it will probably be only on the roll in the third quarter, maybe of 2024, if we're lucky, and then the judgment is still going to come out. So maybe 2025, but at this point, I wouldn't really hold my breath. But the short answer, Lauren, not yet. Shortest period is 2 years, but probably a more extended period into the future.
Yeah, 100%. And I think the Concord, from their side, once the judgment is delivered there, if they then, concur to say the clauses are unconstitutional, they still have to give the government and the policy changes, some time to obviously affect the amendments. It won't just be an amendment to the basic conditions, and it's a question that I want to deal with a little later on, Jandre, but it will also have a ripple effect throughout our legislation, affecting various types of leave, and not just paternity and maternity leave. Jandre, just for our audience, the outcome specifically, if I'm correct, and please feel free to jump in, it's 4 months given per family for a pair of parents. Is that what it's now changed to? So it's changed from the 4 months maternity leave to 4 months that can be shared between the parents.
Parental leave. So basically what the judgment's done is said, listen, the olden day belief that, listen, the mother is going to take the primary care is out the window. They've recognized that in 2023, families are developing, those traditional gender roles no longer exist. We'll get a little bit into the traditional families, specifically within the South African setup, in my opinion about it. But what they've said is, parents should now be allowed to regulate those 4 months as they deem fit. So it's no longer 4 months for the birth mother or the elective adoptive parent and so on. It is 4 months for the family unit that they can set out in whichever way they want. Interestingly, if we move forward to what that says, and especially the 4 months, and firstly, I believe the 10 days, the traditional paternity leave, is a bit of a problem, because that's now falling away, because now people that want to follow the traditional route are actually losing those 10 days. And we must take into account that when the changes came to include paternity leave, the birth of a child was excluded, from the family responsibility clause. So all of a sudden, you're blocked to the 4 months, where originally, before paternity leave, fathers would have been allowed to take the family responsibility leave, the traditional father. And after that, they were allowed to take the 10 days. But that, if this judgment is followed to the letter, we're losing all of that. So if the family wants to keep traditional, have the mother go on a 4-month, or the elective parent in adoption go on the 4-month maternity leave, there will be no benefit for the other parent at this point, which I believe is something they'll need to address when they're looking at the legislature, because it doesn't help saying, listen, we don't want to discriminate between gender roles anymore, but now all of a sudden we're discriminating between people who want to follow the traditional route, 4 months for the mother and a few days for the father, because that has now disappeared, which would mean if the father wanted to take a certain amount of leave, that would have to come down from the traditional mother's maternity leave. So something, I think, a very interesting conundrum for the legislature. This all assuming that the Constitutional Court concurs with the High Court judgment. I personally think, as I said, the winds of change are there. I'm pretty sure that is the trend that they're going to take. But I do believe the Constitutional Court will delve into the rest of the leave a little bit more as well.
I also think the Con Court will provide some more guidance on, panel beating the provisions are to say, listen, we can't necessarily just take this away and slap on 4 months between the pair. I'm sure they will address that in the arguments as well. Genre, just regarding the statutory and physiological requirement for mothers, the reality of the situation is that mothers of a birth child must also take a pre-mandatory period of leave. How does that work now in the 4 months that the parents must share?
Yeah, look, interesting there, because the High Court says nothing about that. They don't go and touch on the medical element of it. Medically, birth mothers must take 4 weeks before the birth, unless obviously a medical certificate or a medical practitioner has stated that they can work a little bit longer. I know with medicine, that has changed quite a bit, especially if you look, and I'm not going to make myself an expert to be a doctor or anything like that, but as the cesareans and C-sections are going, and even natural birth and medicine has evolved, maybe that 4 weeks is a little bit archaic, but I mean, inevitably it is a safety feature for mothers, especially, we have, the Consolidated Employers Organization, some of our officials travel quite a bit, and as management as well, we're quite worried in that last 4-week period, to be sending officials and mothers out during that period. And the same applies for that 6-week period after birth, that out of a safety and health issue, mothers should actually be staying at home, again, unless a medical practitioner and within current medicine says that you can work. So if you follow that to the letter of the law, and a medical practitioner has stated, listen, the mother needs to go all 4 weeks before and 6 weeks after, that really cuts down the extra time to a month and a half, let's call it 6 weeks, that the father can really take. And if you have a look at the judgment as well, it's also unclear, are we going to be able to take this leave concurrently, or
at the same time,
is the mother going to have to take it and then the father going to have to take it? Because take it as a father as well, that 6 weeks after, not all mothers are keen to just go back to work. Again, excluding the father from any leave benefit, during the child's development.
I think one good thing from the judgment, and we'll see what the Concord has to say, but is if parents are allowed to take the leave at the same time, let's say they take 2 weeks or 2 months each. It's a very special time for that family unit as well. But is 2 months going to be enough before both partners have to go back to work? And now we speak about the mandatory period. Let's say the birth mother has the 10 weeks, only leave 6 weeks for the supporting partner as well. So again, it's not necessarily equal per se. Talking about gender equality, it is a good step forward, but I definitely think they'll need to panel beat it a bit.
Yeah, look, I mean, I won't make myself out to be a psychologist. It might be a very good idea once we hear from the Concord to get a child psychologist and a development psychologist on with us to just maybe give that perspective as well. Because if you look at other countries, your more Western countries, European countries, the studies have come out that there's quite a bit of time needed in development of a child. yes, traditionally from the mother as well. But if you have a look at statistics, the father-child bond, also develops during that first period, 6 months. Some countries are giving 12 months and maternity leave to mothers, and a certain amount of benefits to fathers as well. Don't sound the horn. I don't think it'll ever happen in South Africa. The financial structures we have and the support system and the operational requirements, our businesses have, that'll never be. I don't foresee that ever happening in our country unless we take a dramatic economic turn. But I'm also not going to get into that. But yeah, so. Is 2 months enough, per parent? It's a very interesting question, and I'd love to, after the Concord, have maybe confirm this or panel beated this, to get a child psychologist in to just explain to us what the current studies say about the development of a child with either parent during that initial period.
Yeah, because it's not just a legalistic thing that we need to consider here. It's also a human connection thing. It's physiological as well. Chandra, just to move on a bit, I just wanted to clarify quickly. Does the 4 month that is being shared between the parents now apply to adoption and surrogacy?
Yes, that does. It seems that has been extended as well. The 2-year mark for adopted children has remained the same. Which is interesting, but that's going to filter through to all the other parents. It's again, it's not just maybe a gender equality thing, but a parental equality thing as well. We, again, as I say, we're in a changing world. There's so many kids that need adopting. So many parents are opting for that, so that they can also get that benefit. And again, to the psychological effect of, even an adopted child, forming that relationship with the parents, biological or not.
That's crucial. Sorry, I'm just looking at our time. We don't want to keep our employers and our audience too long, but I just want to deal with one or two more things quickly, Chandra, while I have you here. What is going to be the ripple effect in other legislation? The things that come to my mind is UIF. What's going to happen with family responsibility leave? What else can you tell our audience regarding the ripple effect of this change?
Yeah, look, I think the court's intention was never to take away benefits. It was to share benefits. So I think they'll definitely have to have a look at the traditional parental leave. I think what we can do, I don't know if they'll have a look at extending the maternity leave period. I don't think that'll happen. But I think the legislature will be missing a trick if they merely exclude those benefits for families that want to live within a traditional maternity leave, paternity leave type of family. So I think there's going to be quite a bit of changes. When moving to the UIF is already quite strained. There's a lot going on there. Who's going to regulate that? I think another thing that's going to come into effect is if parents work for separate employers, how are you going to be regulating? I'm not saying people are going to be dishonest, but I always speak about the 10%, that sometimes exists to try and bend the rules. But how are two companies going to regulate if the two parents are not both taking their 4 months, basically their 4 month maternity leave? I see that we're frozen. I don't know if there's anybody else that's experiencing the same problem. All right, no, it seems we're not really. So how's the UIF going to regulate that? And yes, it'll probably be an easy answer to say, yeah, but they'll be able to pick up a married couple that is registered, has the same surname. But what about unmarried couples? What happens there? What happens where the mother's company pays full maternity benefits and the father's one doesn't, or the other parent's one doesn't? So it's quite a rigmarole. It's quite a rigmarole to regulate it. I'd like to hear what the legislature is going to come up with there. I do strongly believe that they'll be proposing changes that need to happen, and it'll in all inevitability be open for public comment, which is something we'll as an organization obviously send through to our members, get mandate on. How they would feel it should work. So it should be quite interesting. I don't think it's a one size fits all. I think you're going to have a lot of regulations to try and regulate it. And as I said, by an already very strained UIF fund.
Jandre, I want to say thank you for that. Sorry, I'm just busy reading the questions as they're coming through. I know we are going to be wrapping up soon, but let's see if we can deal with the questions. If any of our audience have any other questions, please feel free to pop them in the comments. I also just want to say that this presentation or this discussion will be made available on our social platforms. For those who have missed it, you'll be able to catch up on it as well there. I see a question came through here from Lauren again. Can employers elect to already implement the new impending parental leave provisions? My quick answer is no. They should prepare for policy changes in future, but currently the status quo remains. So you have to comply with the current provisions. If employers step outside of that, obviously there will be implications for UIF and all of that. Chandra, I don't know if you have a comment on that.
Yeah, look, if it depends. It depends what policy are you looking at. Are you looking at a restrictive policy or a one that elaborates the rights? So you can always enter into a policy or a contractual agreement to the benefit of the regulations as they currently stand. I wouldn't already take away parental leave, but if you want to structure your maternity leave, that'll be difficult now that I'm thinking about it, because obviously the mother still has the full benefit. Would there be a problem if the company tries and elects this and the mother tries to elect it? That would have to be dealt with on a case-to-case basis. I wouldn't have a knee-jerk reaction, Lauren, to answer that. If you want to move to a more beneficial maternity leave, paternity leave policy, do so. As I said, I think the winds of change are among us. It will probably change, but just make sure that if you implement the policy, it's not to the negative of a current right that's there. So don't go and implement this policy to say, listen, parents can now share it, but you take away the paternity leave. You're then restricting a existing right. But start having a look at the policy changes. I strongly believe, when the Concord comes out, it won't be exact copy paste as we have right now in the current judgment, but there will be elaboration and rights will be being shared.
Yeah, I think nothing precludes the parties from agreeing something to the benefit of the parties, as long as the provisions aren't being, as long as there's compliance with the provisions, it can obviously then between the parties in agreement be beneficial. I see there's one last question over here. How would you advise employers to potentially change their policies if they offer partially paid benefits / more benefits paid? And benefits can no longer be afforded to do so under the auspices of the new impending parental leave provisions. I don't know if you can see the question there, Chandra.
I can. Look, Lauren, technically out of a financial perspective, the change shouldn't really affect. I hear what you're saying. So the effect would probably be where the mother's in one company and the father is now all of a sudden getting a benefit. Look, you're going to have to look at that. If you're offering a maternity benefit, a paid maternity benefit, or a partially paid benefit for maternity for the mothers out there, and you are changing your policies where a father can now elect to also take a portion of that maternity leave, the same benefits will have to apply. So you're going to struggle to now, de-benefit your policies because of this change. So just now saying because your fathers will also now get a portion of the benefit, now I'm taking the full paid maternity leave or the half paid maternity leave away. That is going to come down to discrimination if you do that. So unfortunately, the policy is going to have to remain the same. The ripple effect or the complete effect should be the same as it stands right now, because only the 4-month benefit will be taken. Unfortunately, companies that traditionally only gave it to the mothers will now have to give that partial or full benefit to the fathers as well. That's my opinion out of avoiding discrimination. So if you're adapting your policies, it must align to your current policy. Don't take away benefits from people. It might very well come down, and when the act changes, a change of that policy might come down to an unfair labor practice, much like the policies in regards to the National Minimum Wage Act. If you changed working conditions to now all of a sudden try adapt with that or try and limit damage. So I think that will pretty much be your effect if you are removing benefits or you might very well be guilty of discrimination if you don't carry those benefits into the new policy or onto the I don't want to keep on saying the father's benefit, but I mean the family dynamics could just
partner,
be the supporting partner, yes, or the so the main income partner or supporting partner or the mutual partner. What it all depends. So Lauren, I hope that answers your question.
Yeah, John, just before we sign off, I don't see any other questions coming through. Just one loaded question from me to you is in signing off, our advice to our current employers and members, and then also what is your personal opinion on how South Africa as a whole will adapt given our non-conservative approach to change?
Yeah, look, my advice to our employers would be, my apologies, the status quo remains, but start looking and start budgeting. That 2 years was not just for the legislature. I think that 2 year and the period we're going to be afforded by the Concord is also a great opportunity for employers to start budgeting for those type of things, having a look at their demographic within their workplace, and trying to prepare for the impending benefits that might come. So no knee-jerk reactions, but start thinking about it, start working that into your budgets as you move forward, and start doing employee planning on that basis. And open cards with, if you do have organized labor, discussions might be had about that. Information sessions for employers, employees in that regard. Something, CEO could always, attempt to provide to our members. So that's my first thought, and that's going to be our advice to members. Secondly, look, traditionally South Africa, we don't like change, do we? We tend to.
Not when it comes to legislature.
Yeah, we tend to. But okay, again, as I said, this is now millennial. Please don't quote me as an expert on the Gen Z mindset. You'll have to maybe ask the younger generation as to how they go. I think from an older generation thing, the status quo might remain for quite a while before these new gender roles are adopted. But it's, everybody has the freedom to run their family and spend the time with their family as they deem fit. So I think traditionally it might be a slow change, but as the years go on, you might very well, and depending on how the legislature change, what benefits will there still be on a paternity level, or a supporting parents, what benefits will they be getting? So it might be an open and shut book, and people just start using the new benefit depending on what the Concord puts out.
Yeah, I think in summary to our employers, the status quo remains. Should you wish to look at policy changes, keep an eye on the horizon, contact us directly as well if you're a member for advice in that regard. And I think before we go, we have one more question over here.
Yeah, I'm let me read it. Yes, where the mother and father works for different employers. We did address that a little bit. We don't know yet. I think out of a regulatory perspective, that might be a very interesting question. How are you going to ensure that parents that work for different employers don't both take 4 months? But there will probably have to be communication between the companies. So your policy might very well include that upon informing what portion you will take, you need to provide the information of your spouse's employer. So you get that type of communication between the two. So I think that will probably come into the policies. I think a very interesting question is, what if one of the parents are caregivers at home? What happens then? Does the other parent get the full 4 months? Very interesting times ahead. I look forward to our discussion once we get clarity from the Concord.
Yeah. Genre, thank you so much for your time today. To our viewers and audience, thank you for attending and for listening. If you have any further questions, please feel free to pop a comment on the post as well. It will be viewable after the fact, so you can find it on our social platforms if you missed it. And then also please feel free on our CEO website to pop an email to us or give us a call as well if you need any further advice or any questions that you need answering. So everyone, thank you so much, and I hope you have a lovely day. Thank you, Genre, for your time.
Thank you, everyone. Thank you. Bye-bye.